Hi, I'm Terry Cox, Communications Director for the California Statewide Law Enforcement Association, and with me is legal counsel Dave de la Riva. And Dave, you're here to answer a frequently asked question by our members, and it has to do with adverse action. You know, what do I do when I receive a notice of adverse action or rejection during probation?
Right. Notice of adverse action is the formal punishment that an employee may receive. That punishment could range from a dismissal, which is obviously the most extreme form of punishment, to a formal letter of reprimand. Notice of rejection during probation is served on an employee who the department separates from service during the course of the employee's probationary period, which usually lasts 1 year. Some departments it's 6 months, but in general it's 1 year. Now, when an employee receives this type of document, what they should look out for, the contents of both documents. Usually we're looking at 5 to 10 page document which consists of the form of punishment, the effective date of the punishment, charges against the employees, for example, dishonesty, inexcusable neglect of duty, misuse of state property. Those will appear in the body of the adverse action. They will not appear in a notice of rejection on probation. We're also looking at a statement of facts alleged against the employee, prior discipline against the employee, and notice that the employee has an opportunity for what's referred to as a Skelly hearing. The main thing that the employee needs to be aware of and make us aware of if the employee intends to contact CSLEA is the effective date of the adverse action or the notice of rejection during probation. The effective date is important because if the employee intends to appeal the action, the appeal must be filed with State Personnel Board within 30 days of the effective date for notice of adverse action and within 15 days for a notice of rejection during probation. Now, there are differences between the notice of adverse action and the rejection on probation. Notice of adverse action is a disciplinary matter, meaning that the employer has the burden of proving each of the allegations set forth against the employee. The burden of proof is beyond the preponderance of the evidence. A notice of rejection during probation, the employee has the burden of disproving each of the allegations set forth in the rejection document, which makes it extremely difficult for the employee during the course of the evidentiary hearing. It's a very difficult burden to overcome. One thing that the employee with a rejection matter must be aware of is if the employee has come from another state agency and is serving the probationary period and is rejected on probation, that employee has a mandatory right to reinstatement back to his or her former position. So that request to the former employer must be made within 10 days. So it's important for the employee just to keep that in mind.
So Dave, let's talk a little bit about the Skelly hearing, because you talked about that an employee has a right to one if an employee has received a notice of adverse action or rejection during probation.
Right. The employee has an opportunity for what's referred to as a Skelly hearing after receiving either the notice of adverse action or the rejection during probation. Generally, the Skelly hearing takes place prior to the effective date of the action, and along with the notice of adverse action or rejection during probation, under the case of Skelly versus State Personnel Board, the employee is entitled to all the materials that the employer relied upon to come to its decision to take action against the employee. So when the employee receives the notice of adverse action or the rejection during probation, in addition to that paperwork, they'll receive a packet. Usually it can be 10 pages thick, and I've seen packages that look like telephone books. When an employee receives either a rejection or a notice of adverse action, it's very important that the employee maintain the package in the order in which they received it. Because if the employer has failed to serve the employee with some of the documents that the employee is entitled to, that could mean trouble down the road for the employer. So in reviewing all the documents that are served with the notice of adverse action or the rejection, the employee may then proceed to what's referred to as the Skelly hearing. Skelly hearing, as I mentioned, is an opportunity for the employee prior to the effective date of the action to state his or her case, in a sense, to an individual who's supposed to be a neutral party. That individual also has the power to sustain, modify, or revoke the rejection or notice of adverse action, or has the power to recommend to the employer sustaining, revoking, or modifying that same document. There are times when we, as legal counsel, recommend that the employee not proceed with the Skelly hearing. Skelly hearing is purely voluntary. So under certain circumstances, depending on the nature of the action taken against the employee, depending on what type of strategy we may be looking at to take down the road during the course of the evidentiary hearing, which could be a couple of months away, we may decide not to proceed with the Skelly hearing. And that doesn't necessarily put you at a disadvantage. It just means that you're advancing to the appeal process with the State Personnel Board. And after the Skelly hearing, generally, State Personnel Board will schedule what's referred to as a settlement conference. If the action cannot be resolved at the settlement conference, then you proceed to an evidentiary hearing.
You talked about an individual in the Skelly hearing who makes the decisions. Is that individual a judge, someone from the department? Who is that individual?
Generally, it's somebody from the department who is distant, in a sense, from the employee. It's not the employee's supervisor. For example, with the Department of State Hospitals, a lot of the time it will be the executive director, the individual who runs the hospital.
Can that individual from the department be considered impartial and be fair?
I don't know the answer to that, but based on my experience, there are certain circumstances where it's beneficial to the employee that a certain individual acts as a Skelly officer. Then at times it could be a disadvantage. Again, it just depends on the circumstances, and if we feel that it's not going to be to the employee's benefit to proceed with the Skelly hearing, we'll just choose to bypass that process and go directly to the appeal process with the State Personnel Board.
So Dave, in general, what happens in the course of the Skelly hearing? What takes place?
Okay, the Skelly hearing in general will have the Skelly officer in a room. That person may have somebody taking notes. You'll have the representative and you'll have the employee. Again, depending on the strategy that we choose to impose, I may do a bulk of the talking as the representative, or I may have the employee handle that part of the process. This is a non-evidentiary hearing, so it's not a situation where you're presenting your case, you're presenting evidence to the Skelly officer. It's generally handled orally. We don't want to show our hand, so to speak, in advance of the SPB proceedings. And I think what the employee has to realize is, in general, the Skelly officer is there to find out maybe new information that has not been provided in the 5 to 10 page notice of adverse action document. Because what you have to remember is the adverse action document is one-sided. It's the department making allegations against the employee, and those allegations need to justify the level of punishment that's been taken against the employee. So if we're talking about a dismissal case, you can bet that the statement of facts in the adverse action will definitely be one-sided against the employee. When I talk about new information, one of the strategies that I've often come across that employees like to take or may want to take is the what do I have to lose strategy. And believe me, that is not a strategy, and it's definitely not a mindset to take into this type of hearing. Again, the Skelly officer is there really to look for new information, not really, that person is not really there as a shoulder to cry on, and they're not going to show sympathy to the extent that they're going to modify the action just because you decide to shed a tear during the course of the process.
So all in all, this is a pretty stressful time for the employee.
Absolutely, especially when we're talking about a dismissal case. The employee's livelihood is obviously at stake. It's important that our members ensure that they are full dues paying members as opposed to fair share members. We provide legal representation for full dues paying members only, and we provide representation for incidents which have occurred during the course and scope of the employee's duties. So that part is important as well. Especially for those individuals who are on probation, they may not realize that they may not be full dues paying members. They'll see money being taken out of their check, but that doesn't necessarily mean that that's full dues paying money. So it's best that those individuals contact our membership department to ensure that they are full dues paying members, and we'll be happy to provide the services necessary to help them. I, for example, have a case that began in 2009. We're now in 2013. The individual who I'm representing certainly would not have the money, the funds available to hire private counsel and have that person on retainer for the amount of time that it's taken to proceed with his case. So by the fact that this individual was a full dues paying member, it's worked out to his benefit in that he has had representation throughout this almost 4-year process.
And we always want to stress to our membership and to our members that you can reach an attorney when you call CSLEA. There are 6 attorneys here, and when you call, an attorney picks up the phone.
Right. If we're not in the office, our secretary will definitely contact us and make arrangements to get in touch with any employee who decides to use our services.
As always, we want you to know if you have any questions, any suggestions, or need any help with anything, you can email us or you can give us a call. We have an office in Northern California, one in Southern California, and the contact information is there on your screen. Thank you.